All right, good morning, everyone. Um, Welcome to NEPA 101. My name is Sally Bernstein. I work at Sustainable Northwest, and I am here with Susan Jane Brown and Pam Hardy of the Western Environmental Law Center. I will mostly pass this on to them in a moment, but I wanted to get started with a couple of ground rules since we are on Zoom. Please keep your microphone muted throughout this entire webinar. Unless otherwise prompted, we will do a question and answer after the presentation. That will largely be guided by the questions that you ask in the chat box that will come directly to me. Please also keep your video disabled throughout this entire webinar. There's no need to see everyone, and it just takes up a lot of bandwidth. So please keep both of those disabled throughout the next 2 hours or so. Use the chat box to ask questions. You can ask clarifying questions throughout the presentation if you'd like, and then deeper questions we will get to at the end of the presentation. And then anyone who disregards any of these rules, I do have the power to kick you out. So please just be respectful and enjoy the presentation today. So I'll pass it on to SJ and Pam. Thanks for joining us.
Thanks so much, Sally. It's super exciting to get to come here and spend an hour and a half talking about NEPA. I think I can speak for SJ and I both to say that we are both fond of this cool law. I'm gonna see if I can figure out how to get my screen shared and make sure that's all working. Let's see, hit the share button. Ah, this is looking good. All right. SJ, it says you're talking, but I can't hear you.
Nope, I am not talking.
Okay. But now I could hear you, so that's great. So I'm just gonna go ahead. So Susan Jane and I both work for the Western Environmental Law Center. SJ has been litigating NEPA cases for a very, very long time, and I have done some of that, but not so much as her. I'm going to go ahead and begin our presentation, and then I'm going to turn it over to SJ about halfway through. SJ, before we get started, is there anything else that you would like to say by way of introduction?
Nope, I am happy to have you take it away, and then I'll pick up about halfway through.
Sweet. Okay. So the first thing I want to talk about is NEPA. NEPA stands for the National Environmental Policy Act. A lot of people think it's going to be Protection Act. It's actually the National Environmental Policy Act. And when we talk about NEPA, we're actually talking about a collection of three essential things. And when we're talking about law, actually, we're talking about a collection of three essential things. That first thing is the statute or the law that was actually passed by Congress. Oftentimes, when Congress passes a law, they don't include very much detail. And back in 1970, when this law was passed, it was actually January 1st, 1970, that this law was passed, Congress did not write laws with a lot of detail in them. They would just sort of write down what they thought should happen, and then they would allow for the agency that needed to actually carry out those laws to write down more detail about what they thought the best way was to actually do that. Because Congress recognizes that there's a lot of things that, yeah, maybe they know, maybe they don't know, but they generally want us to go in this direction. So in this particular case, NEPA itself, the law itself, is actually one of the shorter laws on the books. You can write the entire law on a 2-page piece of paper, front and back, in actually readable type. So it's amazingly short. The agency that's actually required to fill in all that detail is an agency called the Council on Environmental Quality. And they write what's called regulations. The regulations flesh out exactly what the law, how the law is going to be carried out in some detail. And then the courts interpret wherever the regulations or wherever the statute is a little bit vague, or a situation comes up where people can't agree on what exactly the regulations or the law actually means, the courts interpret that and give us a little bit more nuance to help us understand, when this comes up, they mean X, Y, Z. And so as we go through this presentation, we're going to be referring to all three of those sources of law. So that's what law means when we're talking about this. Excellent. So I've got 3 slides coming up now, all of which have way too much print on them, but they're really important. And so I'm going to do that thing that you're never supposed to do in a NEPA or in a PowerPoint presentation. I'm actually going to read this, but I promise it's actually something that's worth hearing. Okay. So the purpose, this is actually in the law. This is actually the Congressional Declaration of Purpose of NEPA as it was passed. The purposes of this act are to declare a national policy which will encourage productive and enjoyable harmony between man and his environment. Harmony? That's so cool that they wrote that into a law. Anyway, productive and enjoyable harmony between man and his environment, to promote efforts which will prevent or eliminate damage to the environment and biosphere, and stimulate health and welfare of man, to enrich the understanding of the ecological systems and natural resources important to the nation, and to establish a council on environmental quality, which was the council that was going to be carrying out the National Environmental Policy Act. So this is what it's about. This is fundamentally what NEPA says in its own law that it's trying to accomplish. Now, what NEPA actually requires agencies to do is a little different, because purpose and how you accomplish that purpose can be 2 different things. And what NEPA actually requires the federal government to do in order to carry out the purpose is to prepare a, quote, detailed statement for every recommendation or report on proposals for legislation and other major federal actions which may significantly affect the quality of the human environment. Now, there's a couple of terms in here that are really important. It requires federal agencies to do this, to write a detailed statement every time the agency is intending to do something that may significantly affect the quality of the human environment. The detailed statement is something that I think all the people on this call have probably heard of. That's the environmental impact statement, or potentially an environmental assessment or categorical exclusion. And we'll go into exactly what the distinction is between those later. I think that's on SJ's section. But a detailed statement about the environmental impacts of any action that may significantly affect the quality of the human environment. And that word may is really important. If it said will significantly affect the quality of the human environment, that would be a very different question. So NEPA requires a detailed statement if an action might have a significant impact. What actions need to require this statement? Major federal actions. So I think later on, SJ says, things like mowing the lawn do not need a detailed statement. Things like getting new paper clips do not need a detailed statement. This is only for significant federal actions that require a decision. And this is only required by federal agencies. So if a private company wants to do something on their own land, it does not require NEPA. If a state wants to do an action on their own state land, it does not require a NEPA analysis. If a state wants to do something on their own land and they want to get a significant grant from the federal government, and the federal government is going to pay for that, then environmental impact statement is required if the project might significantly affect the quality of the human environment. Now here's where we get into regulations. C.F.R. stands for Code of Federal Regulations, and 1540 C.F.R. 1500 is the beginning of the regulations that are written by the Council on Environmental Quality that help us understand how to carry out NEPA. There's also regulations written by the Forest Service that more specifically fill out some of the Forest Service requirements, but we're not going to get into that much detail. If you want to know exactly where to find those, just put that in the put that in the chat, and we'll make sure that we get you exactly that information so you can get it. So this is another one of those slides. What exactly do the regulations say? Well, they start with this basic idea. Ultimately, of course, it is not better documents, but better decisions that count. NEPA's purpose is not to generate paperwork, even excellent paperwork, but to foster excellent action. The NEPA process is intended to help public officials make decisions that are based on understanding of environmental consequences and take actions that protect, restore, and enhance the environment. These regulations provide direction to achieve this purpose. Whoops. So essentially what NEPA requires. Essentially what NEPA requires is a hard look at the environmental consequences of an action and consideration of alternative ways of accomplishing that goal. NEPA this is our environmental policy. It's that every time the federal government does something significant, they're going to know what they're getting into. They're going to understand what are the consequences, and is there another way I could have done this? Is there another way I could have accomplished this goal? And it requires the federal government to make that decision in the public eye. So the audience for a NEPA document is both the federal government, the agency decision maker, whoever that's going to be, and the public that's participating. Those are two major audiences for this. And the idea is to make sure that the decision maker is fully informed, that everybody who is concerned about the particular event, the particular action, has had an opportunity to comment, and that everything that they've said, all of their comments, have been taken seriously and actually considered in the process. NEPA, one of the questions that we received over and over in the registration questions is, why do we hear people talk about NEPA planning and NEPA projects and so on and so forth? And why is NEPA always associated with planning? And this is a great question, and it mostly just has to do with practicality. NEPA is fundamentally about, as I've already gone over, NEPA is fundamentally about understanding the consequences of an action. And in terms of why does it come always with the planning process? That's just because it's the most practical way of doing it. Technically, it doesn't have to. You could do all your planning separately from doing all your environmental analysis, but it would take a lot more time and money. And so why would you do that? It just makes a lot of sense to plan your action at the same time that you're fully understanding the environmental consequences of your action. And exactly how NEPA does that is there's three fundamental stages to the process. First, and I'm going to go over primarily Forest Service kinds of NEPA projects, because I believe what we all are here is primarily forest collaboratives, I think, are the majority of the folks that I've got here. The first thing the Forest Service does is they say, hey, there's this big area of land. We see that it's not perhaps in compliance with our forest plan, or we think that there's better ways of actually being able to carry out the goals of the National Forest Management Act in this particular area. We're going to take an action, and we think of basically this is what it is. We're going to do budget thinning, we're going to do some prescribed fire, and we're going to restore this particular section of the watershed. And So they come up with their basic proposal, the basic idea of what they think they want to do. That's called the proposed action. And then they take this proposed action before they really have a lot of details about it. And they send it out to the public and they say, what do you guys all think? What should we do? What makes sense in this area? And that's called scoping. The idea of scoping is that the plan is not yet set. There's just sort of a general idea about what they think needs to happen. And the idea is to get as many pieces of information in as they can, so they can understand what the issues are that they're going to be facing. Once they get all the scoping comments in, they go back, they read all of those, and they consider different alternatives. They look more deeply into the analysis. They write up what they think they need to do, and they release a draft EIS or EA. Again, we'll go into those in a little bit. They released a draft EIS or EA, and they say, this is what we think is the best course of action, and this is what we think the environmental consequences are going to be. Hey, public, what do you think? Did we get it right? Are there things that we might have missed? Help us understand this a little bit better. Comment. Public has the opportunity to comment. For an EA, you have, typically it's 30 days, and for an EIS, typically it's 45 days. Those are the minimal amounts of times that the agency has to give. Agency, if it's a complex project, the agency certainly has the option to extend those, but those are the minimal amount of times that need to be given in order for the public to have an opportunity to really sort of digest what went on and, you know, read the document and provide good feedback. And then once they finish that minimal amount of information, or excuse me, once they finish reading all of those comments, once they finish that draft EIS, all the comments come back in, they take all those comments and they look at it and they say, what do we need to update? What do we need to fix? And produce a final EIS. I'm just saying EIS for now, it could be an EA. They produce a final EIS and a draft record of decision. And they say, okay, based on the comments, this is what we think is the best decision. What do you all think? And that's what begins the objections process. The objections process replaces what used to be known as the appeals process. And I won't go into any more detail on that, but it begins the objections process. And you have one more opportunity to say, I think this is not a good decision for these reasons. The objections process requires standing. And standing is essentially, you have to have participated in the lower process. And the idea of NEPA and the idea of the public comment process is good conversation and full disclosure of what's going on. And the idea is that in the scoping process, or at least in the draft EIS process, that if you've got a concern with what the agency is considering doing, that you share that information with the agency to the extent necessary that the agency is able to fully understand what those concerns are and actually account for them in their planning. And the agency actually is required to look at all the comments and actually is required to respond to all the comments. And the idea of this process is to make sure that everyone is essentially putting all their cards on the table prior to a decision being made. So it's not one of those things, you don't want to hide information in this process. You want to just say, hey, this is what I think is really going on. But if you think, once you've gotten at the end of the objection process, if you think that the agency still is not listening to me, once the final record of decision is out, the final decision is made, that's when litigation can happen. And if there's people that are curious about what happens in a litigation process, and I know there's at least one collaborative out there right now that that is going through this, talk to SJ and I and me, maybe we can put together a NEPA 102 or something like that, but it's a little bit much for right now. So you need to have standing to participate in the objections process, and you obtain standing by raising the issues that you're concerned about in the objections process, by raising those in either the scoping or the draft EIS process. The other key question that came up in all the questions that came up during the registration was, what's the best public comment and collaborative engagement process. How should collaboratives engage with the NEPA process? And I think one of the things that most of the people on the collaboratives have probably heard already is that NEPA and collaboration share a lot of principles in common. There's a lot that is very similar between the two. NEPA is all about good conversation. It's all about honesty. It's all about airing the concerns and airing the different points of view ahead of time. And that's exactly what collaboration is about. It's about making sure that everyone understands each other's concerns and is able to come up with better ways of solving the problems based on actually considering all the issues at play ahead of time. So how can collaboratives productively participate in the NEPA process? Field trips are a great way. Go out and see the land. Talk with your Forest Service partners. Talk with each other. Understand what each other's issues are. And then do your darndest to actually participate in writing in each of the phases of the NEPA process. So write something in your scoping comments, write something after the draft EIS, and explain who you are. Explain what the collaborative is. Explain what you like about the project. This is really important and is often missed. A lot of times I feel sorry for our poor public forest employees who just hear negative comment after negative comment. Write down what you think is actually fabulous about the project and write down what you think really makes sense. Write down what your collaborative is agreed on, and if you have formal zones of agreement, attach those to your comments. Put those in the scoping process. Write about the field trips that you've been on. Write about the experts, if you've had any experts come in and talk to the collaborative to help them understand, to help you understand what the issues are and why you've come to the conclusions that you've come to. Fill this all out in letters and send it on in. So that's what I would say. I know that SJ has been involved in a whole bunch of these, and I want to go ahead and give her an opportunity to pick up on collaborative engagement and take over from here. You ready, SJ?
I am. So I am now going to attempt to share my screen. So let's hope that this works. Okay. So Pam did a good job of talking about public comment and engagement from collaboratives. And so I just wanted to add a couple additional things. You know, I think the point about making sure that collaborative members and other members of the public are just really clear and transparent with the Forest Service about, you know, where your areas of agreement are, where your areas of disagreement are, so that it is clear to everyone sort of where everyone stands. And so that's a key piece of information. Sometimes we hear from our Forest Service partners that they're not entirely clear or sure where the forest or where the Forest Collaborative may have ended up on a particular issue. So just trying to be as specific as possible is really helpful to the agency to understanding where people are coming from. Couple other questions that came up in the pre-webinar survey that I want to make sure that we address. One is what to do if a collaborative group wants to litigate in its own name as a plaintiff, for example, or perhaps to intervene on behalf of the Forest Service to defend a collaborative project. And as Pam mentioned, WELC has worked with Sustainable Northwest and others in the past to put together a white paper on administrative and judicial review opportunities for collaboratives. And if there's interest, we can certainly reprise that webinar and make those materials available. But what I would say just from the outset is that if a collaborative does want to enter the fray in the courtroom, particularly as a plaintiff, then you do need to have standing, and Pam talked a little bit about that. That means that you need to have commented throughout the process in order to raise your issues before the agency, before you can go on to court. So that's important. And there are other avenues for collaborative groups who are interested in defending or having their views known in litigation about a collaborative project. So that's a pretty big area of law and of conversation. So if folks are interested in that, we can put something together in the future for those of you who are interested in getting into that a little bit more. But I'm going to go ahead and go on, and I'm going to talk a little bit about some other aspects of the Council on Environmental Quality NEPA regulations, and this will start to flesh out some of those terms and concepts that Pam covered initially. So here at 40 CFR Part 1501 is where you start to get a sense of what types of NEPA documents that the Forest Service can prepare. And there are 3 of them, and they escalate in size and complexity, starting first with the Categorical Exclusion, or CE. And this is the type of environmental document to prepare when the project's effects are so minor, so as to have negligible environmental consequences, such that a project can be excluded from detailed environmental review, and that type of project falls into a pre-approved category of action. So for example, if the Forest Service is putting in a pit toilet at a trailhead, for example, there is a pre-approved category of action for that kind of administrative activity. And if the environmental consequences of putting in that facility are minor, which in many cases, although not all, they are minor, then a categorical exclusion can be the right type of environmental document to prepare for that action. The next type of activity, and this is what we see most of the time, is an environmental assessment, or an EA. And this is the type of document that's prepared when the project is known to not have significant environmental effects. These documents are shorter than an environmental impact statement, but they're longer than a categorical exclusion. And the type of decision document that's associated with an environmental assessment is called a decision notice and finding of no significant impact. So DN-FONSI for short, so lots of acronyms today. And then the third type of environmental document is an environmental impact statement. So this is the long document that is prepared for complex and large projects. And an environmental impact statement is prepared when the agency knows that there will in fact be a significant environmental impact, or when the project may have significant environmental impacts. And Pam highlighted that language earlier on, that if it is unknown if a project has significant environmental impacts, then an EIS is required. So different types of documents there. The type of decision document associated with an environmental impact statement is called a record of decision, or a ROD. Okay, so different kinds of activities are covered under different types of environmental documents. I wanted to spend a little bit of time on categorical exclusions. We're starting to see a lot of CEs used on Forest Service lands for projects. Categorical exclusions, or CEs, are categories of actions that do not individually or cumulatively have a significant impact on the environment. And these are supposed to be activities that have minimal environmental effect, that have been documented to have such minimal environmental impacts through some sort of scientific process, usually through monitoring. And so monitoring is important for a number of reasons. And one of the reasons why it's important is that it can tell us what types of projects do in fact have significant environmental impacts or not. So for Forest Service activities, categorical exclusions are defined in regulation. So there are there's a place in the Code of Federal Regulations where the Forest Service's CEs live. And activities that fall outside of those categories of actions cannot be excluded from an EA or EIS. So if you have a type of activity that doesn't fall within the pre-approved categories, then you can't use a CE for it, and you have to use an EA or an EIS. All categorical exclusions also have to provide for something called extraordinary circumstances. And extraordinary circumstances are the types of resource conditions that are present that if there is a significant effect to those resource conditions, then a CE is not appropriate to document that kind of activity. The Forest Service, and many of you are aware of this, the Forest Service is currently revising its NEPA regulations and is proposing to make some substantial changes to those regulations that would then not reflect, as they currently do, and track very closely, the Council on Environmental Quality NEPA regulations. So the Forest Service is in the process of that rulemaking to change their NEPA regulations. And they are also proposing to include a number of new types of categories that would allow for the exclusion of a project to be assessed with an EA or an EIS. And we got a couple questions about this in the pre-webinar survey. And we can certainly talk more about those individual CEs when we have questions. But in general, the Forest Service's NEPA rulemaking would expand the categories of actions that can be categorically excluded. The proposed regulations would also eliminate scoping for categorical exclusions. So there would be no more scoping, just public notice, probably in the schedule of proposed actions. And the Forest Service is also proposing to change the extraordinary circumstances direction to allow for the increased use of categorical exclusions. So I would expect that we'll see a lot more projects being categorically excluded from detailed NEPA review. There's also, and many folks asked about this, but there is National Forest Service direction to encourage the field to use CEs. So your collaborative or your national forest, you may be seeing a lot more CEs than you have in the past, and there is policy reason for that. So we can talk more about that in questions. So those were CEs, environmental assessments. The purpose, again, of an environmental assessment or an EA is to determine whether the environmental effects are significant. Usually when an EA is prepared, the answer to that question is almost always no. And so you don't then go on to the preparation of an EIS, but rather the Forest Service will rest on the analysis done in the EA. So we're going to talk in a minute about significance, but for our purposes right now, if the effects of an action are known to be significant, then you prepare an EIS because you know that you have significant environmental effects. But if it is unknown whether or not a project will have significant effects, then an EA must be prepared first. And if the EA reveals that the impacts are significant, then an EIS must be prepared afterwards. The agency, in using its scientific expertise, typically decides whether the effects are significant. So this can be a matter of opinion. Oftentimes, members of the public and collaboratives think that an impact will be significant, but the Forest Service disagrees with that assessment. And like it or not, it's the Forest Service's call. If those effects are significant, we can certainly fight that out in court. But in general, the Forest Service gets to make that determination about the effects, the significance of particular environmental effects. There were definitely some questions also that came up in the pre-webinar survey about condition-based analysis. We're starting to see a lot more of these types of projects as well, and often they are documented in an environmental assessment. So we are seeing a lot more use of condition-based analysis. And generally the concept works like this. So when X condition is found on the landscape, then the Forest Service will take Y action and will have Z effect. So it's basically looking for particular conditions that exist on the landscape. And when the agency encounters those conditions, then it will take a particular action that will have expected Z effects. So that's how condition-based analysis is supposed to work in theory. Many folks believe that this is the kind of programmatic environmental analysis that should be assessed in an environmental impact statement. But there is a school of thought that believes that those types of effects, even though we don't know for sure where specifically we might encounter X condition, that those types of effects can be analyzed with an environmental assessment or even a categorical exclusion. There is concern that with the condition-based analysis approach, that site-specific effects are unknown at the time that the project is proposed, and therefore those effects may escape analysis. So there is a lot of concern about that, and that's often why these types of projects are opposed by the public. Programmatic environmental analysis, though, is a thing that NEPA anticipates, and it can be an effective way to operationalize adaptive management where project implementation informs the next phase in a project. But that does mean that you need to have monitoring in place to catch those effects, and you need to have an adaptive management in place so that if you are getting unexpected effects, then you change management accordingly and make sure that those environmental consequences are analyzed and captured, and that the public has the ability to comment on those expected environmental consequences. So to be effective, condition-based analysis requires monitoring and triggers for when additional analysis and public engagement would occur. And courts have both upheld condition-based analysis and courts have struck it down. So it is a type of analysis that, depending on the court and depending on the facts of the situation, may or may not be a good way to capture environmental effects. And we can take more questions about that during question and answer session. So that's environmental assessments. And we're going to talk a little bit about environmental impact statements in a second, but we're going to skip to alternatives. Alternatives are designed to address different ways of satisfying the purpose and need of a project. So if a purpose and need of a project is to restore a particular segment of a river, there may be a variety of different ways of doing that. Sometimes you might just want to leave it alone. Sometimes maybe you want to remove old dam structures. Sometimes you may want to do some riparian planting. There may be different ways to achieve the same objective. So the alternatives requirement in NEPA is designed to facilitate the development of those different alternatives, different ways of achieving a project's purpose and need. A reasonable range of alternatives is required for an environmental impact statement. It is not technically required for EAs, but Forest Service practice and the current Forest Service NEPA regulations do require for alternatives to be included in an environmental assessment as well as an environmental impact statement. And for that reason, because we're looking for different ways to achieve the purpose and need of a project, the alternatives section is considered the heart of the environmental impact statement or environmental analysis, because we're looking for different ways to get at the same problem. Alternatives analysis requires the agency to consider a no action alternative as well as action alternatives. And alternatives, it's important to note, can include a proposal submitted by a collaborative group. So if your collaborative has different ways of achieving the same objective that the Forest Service does, you should and can submit that alternative to the Forest Service for their consideration. Effects analysis. This is where the meat of the environmental analysis is generally found. We're supposed to, and again, this is the whole point of NEPA, is to disclose and discuss the direct, indirect, and cumulative effects of the agency's action. So we want to know what all of these alternatives, how they're going to affect the environment. And that's 1502.16 of the regulations requires that kind of analysis. So this is where the bulk of the meat of either your EA or EIS is going to be found about the effects analysis, which makes sense because that's what we're concerned about, is how a project is going to affect the environment. Science, so NEPA is also places a premium on the utilization and consideration of science. And this particular regulation requires the use of accurate scientific data and requires the Forest Service to state the methodologies it used to arrive at its conclusions. So this is part of the transparency requirement of NEPA. We want to know what science was used to develop a project and to assess the environmental consequences of the project. So how did the agency do that? And NEPA requires that information to be disclosed. The use of local science can be a really great way to develop common ground and understanding about ecological processes in a particular place. For the Blue Mountains Forest Partners, which I work with, we have done a whole bunch of local place-based scientific research and inquiry that's actually resulted in peer-reviewed papers that talk about what's going on in our particular place and what some of the causes of that are. And then it's really up to the public to decide what to do about that. And utilizing science can be a good way to come up with those alternatives and those projects. Cumulative impacts. A lot of folks like to talk about cumulative impacts. I'm one of those people. Cumulative impacts and the regulation here describes cumulative effects as the impact on the environment which results from the incremental impact of an action when added to other past, present, and reasonably foreseeable future actions, regardless of what agency, federal or non-federal, or person undertakes such other actions. Cumulative impacts can result from individually minor. So cumulative effects here, cumulative impacts are designed really to capture not only the effects of the proposed action, but also the effects of projects that we know are proposed that are nearby this particular project. So maybe we know that, for example, the Bureau of Land Management is proposing a timber sale right next to the Rogue River Siskiyou National Forest. So we need to know what BLM is doing on their land so that the Forest Service can accurately assess how a timber sale or a collaborative project on the Rogue Siskiyou has synergistic effects with the BLM's action. Same thing with private actors. If you have, the checkerboard is a good example of this, where you've got the Forest Service, the BLM, and private timber industry lands located in the same checkerboarded watershed. We kind of need to know what everybody is doing so that we know what the synergistic effects of all of those actions are going to be on, for example, spotted owls. So the NEPA regulations require that kind of analysis and disclosure to take place. And often cumulative effects can be very significant, even if a project has small effects itself. So looking at that big picture look is what this regulation is designed to get at. So significantly, this is also where the rubber meets the road. The outcome of the environmental analysis determines whether an EA or an EIS should be prepared. And the key question here is whether the effects of an action are significant. So how do you determine whether or not a project's effects are significant? In this regulation basically walks you through that process, and that's how you get there. The regulation specifies that there must be a consideration of environmental effects in terms of context and intensity. So context and intensity. The context and intensity will change depending on the project, the geographic setting, and the identified issues of concern of the project. So context and intensity, it's kind of like about real estate. Location matters and size matters. And so we will look at the impacts of a project within that setting. So whether it's both the context and intensity. There are 10 significance factors. And I'm going to talk about those in just a second. But those significance factors are basically what you're going to be evaluating a project against to determine whether or not an EA or EIS is the appropriate document to prepare. It's also important to know that significant effects can be beneficial, not just adverse. And the regulation is really clear about that. Usually we're focusing on adverse effects to the environment, but this regulation does apply to beneficial impacts to the environment as well. So those significance factors are things that would commonly come to your mind. So for example, effects to public health and safety, unique characteristics of the geographic area. So maybe it's a unique geological feature, for example, is in the middle of your planning area. That would be a unique characteristic of the geographic area. Highly controversial effects. And it's important to note, because this comes up a lot, is that highly controversial effects does not mean that there is a lot of opposition to a use. And the case law talks a lot about this. So highly controversial does not mean that there is a lot of opposition to a use. Instead, what it actually means is whether there are questions about a project's effects. So controversy in this case is uncertainty, not opposition to a particular use. So it's important to note that. Other significance factors include highly uncertain or unique or unknown risks, which is very similar to highly controversial effects. Here, the case law tells us that highly uncertain or unique or unknown risks highly means highly, not just that there's some disagreement out there, but rather that there is substantial disagreement or substantial uncertainty about something. So that's important to note as well. Other significance factors include precedent-setting actions. So for example, this is the first time the Forest Service has ever done this type of project. That would be precedent-setting. Whether there are cumulative effects to significant scientific, cultural, or historical resources. So for example, if a particular area has a lot of cultural resources, Native American sites, for example, that can be a significance factor to consider. The effects to threatened or endangered species or their critical habitat, and threatened violation of federal, state, or local law for the protection of the environment. So those are the 10 significance factors. And depending on the impact of a project to those significance factors, an EIS may be required or an EA may be sufficient. So it depends. It will be a site-specific inquiry there. A question came up in the pre-webinar survey about whether the litigation process mechanically is different if the project is documented with a CE, an EA, or an EIS. And the answer there is that the litigation process itself, the mechanics of filing a lawsuit and going through briefing and oral argument and that sort of thing in court is identical, regardless of the type of environmental document that's prepared. So whether it's a CE or an EIS, if you're at either extreme, doesn't matter. The litigation process goes exactly the same. It may be different whether a court is willing to grant an injunction stopping a project if the project is very small or if the project is very large. And frankly, the case law is all over the map on the answer to that question. Again, it's going to be a site-specific inquiry, and it'll be up to your judge to determine whether or not an injunction will issue. And there are lots of factors about that that we can also talk more about, but it's a little far removed. It's a little bit removed anyway from our NEPA 101 webinar today. So I think that I wanted to stop there. Pam and I are certainly happy to talk a little bit about how the Blue Mountains Forest Partners goes through our NEPA process with our Forest Service partners. But I think I'll probably just turn it back over to Sally and see how we want to do questions and that sort of thing. So I definitely want to leave as much time as possible for questions.
Awesome. Thank you, Ashay, and thank you, Pam, for that presentation. I think that the best way to do questions will be for everyone to, if you do have a question, type it out into the group chat. That will come directly to me. And that way, if we have similar questions and whatnot, we're not all asking the same thing at the same time. So why don't we take a moment or two, and if you have a question, send it over, and we'll go from there. So we do have one question. Can you repeat the 10th significance factor?
Sure, 10 significance factors. And we can also provide this information to folks after the webinar too. But the significance factors are, let's see, I'm gonna start here. Effects to public health and safety, unique characteristics of the geographic area, highly controversial effects, highly uncertain or unique or unknown risks, precedent-setting actions, cumulative effects, effects to significant scientific, cultural, or historical resources, effects to threatened or endangered species and their critical habitat, and threatened violation of federal, state, or local law for the protection of the environment. And those are all found also, and I will let you all know that those significance factors are found at 40 CFR section 1508.27, and they're all listed out there as well for you.
We have another question here. What does NEPA say about serious consideration of comments from the public? For example, actually addressing the comment or cut and pasting answers from already published NEPA documents.
Yeah, so what I would say about that is that technically the Forest Service only has the obligation to respond to public comments when they prepare an environmental impact statement. That is per the CEQ regulations. That said, the Forest Service often prepares a response to comments for environmental assessments as well. So sometimes you'll see that. And I can sympathize with a response to comments that you don't feel actually answered your question or actually responded to it. Sometimes that happens and it's not very fun. But there is no sort of, there's no requirement for the content of a response to comments statement. The agency, the CEQ regs and the Forest Service regulations don't provide that specificity. They instead just say, you got to prepare a response to comments if you do an EIS. So sometimes those responses to comments will be great and actually address your question or respond to your comment. Other times they won't. And unfortunately, that's just the way that it is. Pam, would you disagree with that? Oh, you're on mute.
There we go.
There you go.
Thank you so much. That's right. It's frustrating sometimes when I don't get a response to my comments, or I feel like the person who read it perhaps didn't understand it, but to some extent, that's just the way it is. One of the reasons that the Forest Service, I understand, has often tries to cut and paste is because what they're trying to do is refer you back to just the place in the document that already addressed that. And sometimes that works and sometimes that doesn't, because I feel like, I often write the comment because I feel like they didn't fully address it, but that's how it goes.
So the next question, the Forest Service is considering adding determination of NEPA adequacy to agency regulations. Can you talk about how that fits into CE specifically and how is it different?
That's a good question. So determination of NEPA adequacy is a thing that the Department of Interior has and has used extensively, typically in the context of oil and gas development, which is a phased process. So when a big programmatic decision is made, and you know that there's going to be site-specific action, but you're not really sure when or where or what that's going to look like. When the agency then proposes that site-specific project in the oil and gas context, it's usually they're issuing a lease for an actual well, for example. The Department of Interior has this thing called a determination of NEPA adequacy, or a DNA. And it's essentially a checklist, and it says, does this one well, for example, this lease, do the effects differ than what we thought was going to happen in the programmatic NEPA analysis? And if not, then you check that box and that well and that lease can go forward. So that's sort of how Interior does it. And the Forest Service is very interested in having that authority as well. And so their proposed NEPA regulations, which are not final yet, although they are nearing the finalization process, nearing the end of the line, the Forest Service would like to use the determination of NEPA adequacy authority for programmatic actions and site-specific implementation of those programmatic actions. Now, point of fact, the Forest Service doesn't have that authority currently, so we don't really know for sure how that would work when it comes to Forest Service actions. And there is definitely concern that many have voiced, and myself included, and well concluded, that we're concerned that this tool would be associated with condition-based NEPA, and that you might have a very large, very broad programmatic document that says, you know, when we find, for example, beetle kill out on the landscape, then we will do this type of timber harvest, which will have that kind of environmental effects. We are concerned that the coupling that kind of approach with a determination of NEPA adequacy allows the agency to basically not assess site-specific environmental consequences and to not involve the public when site-specific project actions are being undertaken. So there is a lot of concern about DNAs and condition-based analysis, and that concern is further augmented when you talk about expanding the types of CEs that might be available for the agency to use. Because now you're talking about moving a lot of ground disturbing actions into CEs, which under the agency's proposed rulemaking would not require public scoping. Meaning the only way the public would know that those actions were happening is if you happen to read the schedule of proposed action. And that action is actually published in the SOPA, which sometimes they aren't. And so there's a lot of concern about the lack of transparency in environmental analysis and public engagement with the DNA concept. But we're not entirely sure how it would work because the Forest Service doesn't have that authority currently. So that's, I think, the best that we can suspect might happen.
Great. Let's move on to what are the primary legal vulnerabilities forest collaboratives need to be aware of when it comes to cumulative effects analysis?
You want to talk about cumulative effects, Pam?
Yeah, sure. I'll talk about that. I think one of the big things that I'm seeing going on in one of the trends that I'm seeing in cumulative effects analysis is limiting the scope of where they are considering a cumulative effect. And I think that that's a vulnerability that I've seen in a number of documents. And I think if a collaborative group were to get together and to think about what makes sense to the collaborative group as the scope or scale at which they think cumulative effects are actually important to consider, I think that that would really help the Forest Service be able to write a much better cumulative effects analysis. So for example, think about taking a normal timber sale. You know, say you have a 10,000 acre project and it's got, you know, 3,000 acres of actual thinning and maybe an additional 2,000 acres of pre-commercial thinning, and then it's got, you know, 8,000 acres of prescribed fire in it. And that's going to be a significant effect, but the cumulative effects are what is happening in the surrounding areas. How are wildlife that are intersecting, who are using that as a part, but perhaps not all of their home range, how is that treatment going to affect the wildlife that live there, but also the wildlife that might migrate through there? How is that going to affect fish? Like maybe this project area has an opportunity to significantly affect a river that is home to anadromous fish, and this is a source of cold water. So some of the cumulative effects or potentially indirect effects might be on the fish downstream. And so a conversation inside a collaborative about what is that scope at which we want to look at cumulative effects and what does the collaborative think is a reasonable area would actually, I could imagine that being a big assistance to the Forest Service in terms of providing some evidence that the scope of their cumulative effects analysis made a lot of sense and made sense to a wide variety of people. Anything else? Read me the question again, make sure I got that.
What are the primary legal vulnerabilities forest collaboratives need to be aware of when it comes to cumulative effects analysis?
Mm-hmm.
SJ, anything you'd add?
No, I think you covered it pretty well. I think folks are going to know what sorts of potential cumulative effects are lurking out there because you all know your landscape, whether it's grazing effects or private timber harvest or, state action or whatever it is. But, I think most folks have a pretty good sense about what's going on in their own neck of the woods, and those, you see those effects out in the landscape. So that's kind of what we're talking about.
All right. Can you talk more about why the U.S.F.S. is reconsidering the NEPA rulemaking, particularly why the scoping period may be eliminated?
Gosh, I wish I could read the Forest Service's mind. I think that in terms of scoping, what the explanation that I've gotten from the Forest Service about why to eliminate scoping for CEs is that nobody cares about activities that are CE'd. And since nobody really cares about activities that are CE'd, then we can save time on the process side by not keeping a project open or making a project available for scoping comments, because then the public might respond and then the Forest Service would need to do something with those scoping comments. So it's generally seen as a cost and time saving device. I don't agree with that justification at all. I think that these are still actions that affect public lands that are owned by all Americans, and we have a right to have our say, even if it's a small action. And the fact is that the Forest Service already has 36 different categories of CEs that they can use for land management decisions. And the proposed regulations would add several new categories of CEs, including for some very large actions, ground disturbing activities of up to 7,500 acres, for example. And those are big actions. And I think the public does care about those actions. So, I think that's the Forest Service's explanation for it. I don't agree. And I think it's problematic, again, because there's a lot of types of things that can happen on the land with a CE, and shielding the public from knowing about those actions, I don't think is a very good trust building exercise either, in addition to the possible negative environmental consequences they may have.
Okay, why are CEs being used more, and has this led to increased litigation?
So again, CEs are being used more, first of all, because there's national Washington office direction to the National Forest to use more CEs to get more work done on the ground. Part of that is coupled with the Forest Service's flagship targets, which is how the agency measures its performance, which are twofold: board feet and acres treated. And so if you are trying to get more board feet and acres treated, categorical exclusions can be one way to do that, because they typically are shorter documents and don't get the same sort of public scrutiny that an EA or EIS does. And are we seeing more litigation around CEs? We're starting to. It's going to take some time. Generally speaking, on average, it takes about 3 years to litigate a project, in my experience. And so, if I file suit tomorrow on a categorical exclusion project, we're probably not going to have a decision from the courts for 2 to 3 years. And so litigation, whether litigation is increasing or not, there's sort of a lag effect, and we're not going to really know that until probably a couple of years from now. But my sense, sort of informally and talking to my attorney colleagues, is that, yeah, we're seeing a lot more CE projects, and we're seeing a lot more actions that we don't think should be categorically excluded from detailed NEPA analysis. And so you're seeing a lot more litigation. And I think that's, the Forest Service's justification for revising its NEPA regulations has been that they would like to decrease their litigation risk. And my personal opinion is that this is not the way to do it, by categorically excluding more types of activities. But that's my personal opinion.
I'd like to jump in on this one a little bit too. I think, what SJ said was really important. And I went to a conference a little while ago that was looking at the efficiency of NEPA projects that came out of collaborative groups. And they had a very, because all of this is driven by efficiency. The Forest Service is concerned that the NEPA process is taking them a very long time to get done. And they're concerned that it's sort of just mucking things up and slowing things down. One of the things that they said in that conference that I found really curious is that NEPA projects that have in-depth collaborative attention to them, they don't go faster. But what they do get done is more acres per day spent planning and better quality outcomes per day spent planning. And as a collaborative, that might be something that you can think about when you're helping your Forest Service, your local Forest Service partners understand whether or not they're actually getting a good deal for the amount of time they're, say, putting into an EA or an EIS as opposed to an EA. Are they getting more acres done better?
Yeah, I think that's a good point, Pam. And the other thing that I'll add, just because I can't help myself, is that we often hear, certainly as a litigator, I hear this all the time, and I hear it as a collaborative partner as well, is that the Forest Service gets sued all the time, and they spend all of their time in litigation as opposed to managing public lands. And there's been a fair number of peer-reviewed scientific literature that has debunked that claim. And in particular, there was a recent study that came out that was published in the Journal of Forestry, which was also peer-reviewed. And Dr. Fleischman and his team looked at the PALS database, which many of you are familiar with, and did a lot of number crunching and concluded that, in fact, the Forest Service has a very, very low litigation rate, and it is decreasing. And the agency is planning less than they used to. And there are some reasons that Dr. Fleischman was hypothesizing about why that might be. But I think it is interesting that the conclusion from yet another research paper is that litigation does happen against the Forest Service, but it's actually a fairly rare occurrence, which isn't to say that, if you're a Forest Service person and your project gets challenged in court, it doesn't mean that you don't feel that. But what it does mean is that it doesn't happen as often as it may feel like it does. And I think that's pretty important to keep in mind out there, particularly because if we want to increase the efficiency of NEPA or the planning process, there are ways to do that without circumventing or streamlining the law.
Okay, could you talk to the role of tribal consultation in NEPA and or within Section 106 review process?
Yeah, so government to government consultation is required by a number of laws. NEPA also makes provision for that. And the upshot there is that the Forest Service, as the federal government, has an obligation to consult on a government to government basis with recognized Native American and Alaska tribes. And of course, there's a lot fraught with that because there are a number of tribes and Native peoples that are not recognized by the federal government. But for those tribes that are federally recognized, the Forest Service must consult early and often with those tribal entities. And the idea is that as you would with another government, you want to let that government know what actions you might be taking and whether the other government, in this case the tribes, have concerns about that action, either because it affects treaty rights or because that action's occurring on former or current reservation lands, for example. So that the government to government consultation happens on a parallel but separate track from the government's or the Forest Service's public engagement with collaboratives and other members of the public. So tribes do have a different and special process that they utilize or can utilize. Tribes can also utilize the NEPA process, and many tribes do. But as a sovereign nation, those tribes have different processes that they can utilize in order to have their concerns heard and addressed. Pam, do you have anything you want to add to that?
No, I think that covers it.
How can the public continue to hold the Forest Service accountable with the proposed changes and cuts to public comments and involvement?
Yeah, that's a tough one. If you don't know about a project that's going on, it's really hard to stay involved in what's going on. I think that my experience has been that participating in the collaborative process, you hear about a lot more than you would otherwise. Staying up to date with what's on the SOPA, the Schedule of Proposed Actions, is also a very important way of doing that. And if you want to find that schedule, the easiest way to do it is type in SOPA with the name of your national forest into Google, and it'll pop right up. But as long as you have, this requires vigilance on, on the part of the collaborative or on the part of your organization to stay up to date with what's going on. And my experience has been that to the extent that you are a really productive partner in terms of, asking good questions and, understanding what the concerns are and so on and so forth, that the Forest Service will be more likely to share with you what exactly is going on. If it's something that's going on under a CE, and there's no scoping process, you're probably going to have to find it in the SOPA, or you're probably going to have to see evidence of it going on somewhere else. But yeah, staying in good communication is probably the best way to do it.
Yeah,
SJ, what would you add?
I agree. I mean, again, WELC is very concerned with the Forest Service's proposed regulations. And I'd certainly be happy to share our formal comments that we worked on with a large coalition of groups on the agency's proposed rulemaking. There are a lot of concerns, and the public should be very concerned about projects that are not publicly well publicized. And I think the only real way to do that, as Pam said, is to keep up on the SOPA. But unfortunately, usually the SOPA is published quarterly. And so it is entirely possible and probably likely that in between publication, new categorical exclusion projects may be proposed and frankly implemented before the next SOPA is published. At least that's the concern I have. And so how do you know what's going on? I think calling your local Forest Service ranger a lot is going to be probably the best way to do it. Again, from an efficiency standpoint, I don't see how that actually helps the Forest Service increase efficiency if the district ranger is going to have to be doing nothing but answering the phone when people want to know what's going on in the district because now they're proposing all these new CEs. So I don't know as though the Forest Service is really thinking about that, how they are going to process the increased public attempted scrutiny of more CEs and more projects where detailed comment is not permitted. I don't see how that works out well for the agency long term, but it is what they're proposing to do. It's possible that perhaps the agency will reconsider its proposed rulemaking. But as of now, we're assuming that that rule will go final sometime this summer. So we'll find out.
Great. Can you talk a bit about iterative NEPA? What is the basic premise? What are the benefits and constraints? And are there some good case examples where iterative NEPA has been used?
Do you want me to take that?
Yeah, I'm thinking what you're talking about is cases where there's a NEPA project or there's a NEPA analysis and then something happens and NEPA needs to be updated. Is that what you're thinking? Is that what you think?
Well, it depends on how it's being used. A lot of folks use the phrase iterative NEPA in the same way that people use either programmatic NEPA or adaptive management. And generally the way that iterative NEPA is supposed to work is kind of a hybrid between programmatic and condition-based NEPA and adaptive management, which is to say, we're going to do this activity over here and we are doing some sort of monitoring, and we expect that based on our action that one of two things is going to happen, and based on whichever one of those two things happen, then we will do additional analysis on whether it's option A or option B. And then through that iterative process, we will then have an additional decision down the line that responds to on the ground conditions. So that's how I've kind of heard it described. For me, I don't know as though the words we use matters as much as what is happening on the ground, and are those environmental effects analyzed and disclosed, and does the public get an opportunity to have their say about them? And, you know, frankly, I have not seen iterative NEPA work very well. It can, but I haven't seen it work all that well. One type of example that's often held up is a project that was done in the Black Hills in the Dakotas. And that was focusing on beetle mortality and harvesting to recoup that economic value. And I think part of the purpose and need was to reduce future susceptibility to insect attack. That's often a project that's held up as being an iterative NEPA process. To me, it sounds a lot like programmatic analysis. It can also be considered to be condition-based analysis. You know, it can work, but I haven't seen it work super well. So I don't have any good examples for you that I have personal experience with that I can have an opinion about. I don't know if you have any examples of that, Pam.
I don't have any personal examples of that. And I would just warn that any project like that depends on monitoring, the monitoring results ought to be pretty easy to understand and pretty easy to obtain. It shouldn't require a lot of detailed work that may or may not actually get funded. Members of the public should be able to tell whether or not the trigger has happened.
Yeah, and I think that's the problem with either condition-based analysis or programmatic analysis, is that, first of all, monitoring has to occur because you have to know if what you're doing is giving you the outcome that you wanted. And then you also need to adapt and change. And those two things sound really simple, but I think we all know that, for example, monitoring is always the last thing that gets funded and implemented, if it does at all. And so you may have a great, you know, condition-based project with all of these great triggers and requirements for monitoring, but if the monitoring doesn't happen and then you don't integrate what you learned into the next phase, you know, you're not really doing what you said you were going to do. And again, I think that's a trust building issue that the agency often has with the public and other stakeholders.
Here's a clarifying question. What are the time differences between a categorical exclusion, an EA, and an EIS? How long does the processes usually take?
It depends on the complexity of the project. It really, there's not a specific set. I think the new Forest Service rules recommend specific numbers, but exactly what is required really depends on the complexity of the project involved. I have seen CAs take as little as a month or a couple months to well over a year, and EISs take multiple years, and EISs take just a few months. It really just depends on the project that you're dealing with.
Yeah, I think that's right. For public comment periods, you've got 30 days for an EA and at least 45 days for an EIS. But beyond that, Pam's right. It really kind of depends on the complexity of the project. And, there are huge EISs that have taken less than a year. And there are pretty small EAs that have taken multiple years. So it really just kind of depends. I think the other really key thing to note about how long it takes to do NEPA is that aside from the either statutory or regulatory time periods, which I just mentioned, there are a whole host of external factors that influence how quickly a project goes through the NEPA process and gets implemented on the ground. And top on those lists include agency funding and staffing and training. I think we're all pretty familiar with the detail process with the Forest Service in terms of folks that are moving in and out of temporary positions, and often positions that are really key are vacant. So if your district wildlife biologist is a vacant position and there's no body in that role, it's pretty hard to draft a wildlife analysis for an EA. And once that position is filled, maybe it's filled with a detailed person. So person's not actually from the Ochoco National Forest, they're from the Monongahela. And do they know anything about Eastern Oregon? Maybe, maybe not. But it's going to take them some time to understand and get up to speed. And in the meantime, you've lost weeks or months on the process. So, there are external reasons why the process takes a long time. But very few of those reasons are related to NEPA itself. It's more about external things, how the Forest Service staffs projects, whether there is funding on the forest to do, a trail project, for example. Do you have any recreation dollars in your budget? If not, then you're probably not going to get that trail project done in an expeditious fashion. So there are a lot of different things out there that can affect how quickly a project gets done, far aside from the NEPA process itself.
Thanks, guys. I have a request, and I think it'd be great to hear from you about this. It'd be great to hear from the speakers how BMFP has approached the NEPA process.
Yeah, Pam, do you want to talk about that?
Sure. BMFP has been very closely involved in lots of NEPA projects, lots of big projects going on. And usually what we do is, well before scoping even goes out, while the Forest Service is just in the very beginning process of trying to figure out what they're going to do, we go out and do at least one, if not 2 or 3 field trips to an area, get to know the area, talk amongst ourselves about what we think the issues are that are going on there, talk to the Forest Service staff that are just starting to turn their attention over there and see what's up. And then we use that information to the extent that we can to inform zones of agreement or inform scoping comments. The BMFP has pretty extensive zones of agreement that we make sure that the Forest Service has when beginning any project. If it's going to involve just classic timber kinds of treatments like thinning, prescribed fire, PCT, that sort of thing. Or if it's going to involve aspen, we make sure that the Forest Service has that and considers that. as the Forest Service gets further involved, gets the scoping out there, they return back to us. They let us know what the issues are that have been raised. Sometimes we'll go out and look at particular places, and just make sure that, you know, as particular thorny situations come up, that we stay in touch with them and talk about it internally as much as we can. That's mostly been our process. And I feel that my experience has been that the Forest Service, it pays a lot of attention to what we can agree on. There have been, you know, there's a lot of things that the collaborative hasn't fully come to agreement on, and we're not able to say anything about those particular things. And so we just have to sit back and all write our own comments, or just be like, but you know, that's the deal with the collaborative, is that you write about the things that you can't agree on, and people generally still retain the opportunity to have their own say about what they think should happen otherwise. SJ?
Yeah, I think that captures it pretty well. You know, BMFP uses field trips a lot in our deliberations because it gives us an opportunity to be in a specific place and talk about specific issues and, you know, stands and what we think we want to do. We also, as I mentioned before, we make a lot of use of place-based science that we've developed generally as part of our monitoring program. We have on the Malheur, we have a collaborative forest landscape restoration project. And part of the funding that the Forest Service receives from that is dedicated to monitoring. About 10% of our CFLR award goes towards monitoring. And so we're developing a lot of place-based information about existing conditions as well as monitoring implementation. And so we use that information as, you know, we try to do adaptive management. We're using the science and the data that we're gathering that then influences where the collaborative would like to see the Forest Service go for our next project. So for example, early on, we were trying to figure out how to protect aspen. And one of the things that we thought we would try is we would hinge small diameter trees around aspen patches. And so when you hinge, you don't cut the tree all the way off, you just cut it a little bit and then it kind of flumps over. And the idea was that if you did that around the aspen patch, it would create sort of a natural barrier to cows and deer and elk. And our collaborative thought that was a great idea. And we're like, oh, it was perfect. It was great. We don't have to pay for a fence and we're going to save all the aspen. And turns out that didn't work at all. The first winter came and squished all those flumped over trees down with snow. And then it made it really easy for all of the ungulates to go get the aspen when they started to sucker in the spring. And so we learned from that and didn't propose to do that again because it didn't work for us in our landscape. And so we've kept those sorts of lessons in mind as we move forward into our next projects. And instead of proposing hinging to protect aspen, we're proposing some fences because that's what we need. And so we do try to, you know, develop when we have questions, when our collaborative has questions that, you know, what does the science say on a particular issue? Then we work with our science advisors to provide us with more information. And that really helps us infuse that into the NEPA process, because then we've got local data and local information that's really essential to knowing what's going on in a local place and how to address those challenges.
Thank you. And so we're getting to the last couple minutes here. I think just one final question I'd like to pose to you guys would be, what's your general advice to people who are participating on here who are newer to collaboration?
Build relationships. That's really my first advice, is understand the interests of all the people that are sitting around the table the best you can, and give people an opportunity to really be heard, understand what their concerns are, and not just the people sitting around the table that are, you know, the collaborative participants, but understand your Forest Service folks too. You know, they're human as well. And building relationships all around so that you can call somebody up and say, hey, XYZ happened, and I'm just wondering if you can help me understand what's going on there. Like that kind of quick response makes things really work. For example, I think that the BMFP response to the Canyon Creek fire would be one of the best examples of relationship building actually having a huge impact on how that came out. The Canyon Creek fire was over 100,000 acre fire that happened just outside of John Day and had the potential to, have a huge impact on that community. It did have a huge impact on that community. And BMFP was on the phone and discussing how we were going to respond to that before the fire was even put out. While the Forest Service still had people in the field, the collaborative members were on the phone talking about how are we going to respond to the call for salvage. And that kind of thing is based on relationships. We're able to come up with a result and able to come up with a proposal that was able to meet all of our needs, even though all of us were a little bit like, but we were able to come up with a proposal that was able to meet everybody's needs and have it done in an amount of time that actually worked for the Forest Service and worked for the local community. SJ, that was right when I was beginning with BMFP. You were more involved in that.
Yeah, and I think that's a good example, and I would totally agree. I think, advice to newbies is to approach all of this with an open mind, which can be really hard sometimes. It's hard for me sometimes because even folks that I've known and worked with for a long time in a collaborative setting, sometimes they'll say things that I just don't agree with at all, and that really trigger me, and that's hard. Even if you like someone, and it's even harder if you perhaps don't really like them that much and someone says something that really sets you off. But it's important, I think, to hear what people are saying and to really understand what those views are, even if they are different than yours, because it does help build understanding and relationships. And this is all about relationships. I don't think that, I personally don't see a future where it's just the Forest Service making land management decisions. I don't see us ever going back to that kind of situation. I see that the only way that the Forest Service can really manage our national forests for Americans is with our help. And the only way that they're going to get our help is if we can better understand each other, which again, doesn't mean that we all always agree. We definitely don't. In fact, BMFP disagrees with each other on a number of issues, but we focus on the common ground and where we do agree. And if you start there, hopefully you can expand your areas of agreement moving forward. And I think that's really what this is all about. Just like we, expect the Forest Service to adaptively manage our public lands, I think we should expect ourselves to adaptively manage our own selves, and to grow and learn from each other. So that's sort of what I would advise.
Thank you both so much again for hosting and leading this conversation. Pam and SJ have generously offered to answer questions following up after this. So if there's anything lingering that you still really want answered, please email me and I will make sure that connection is made. Let's see, I'm gonna end your screen, SJ. And so we'd like to take a minute here. Just this webinar is the first part of a series of webinars that will be in place of the Pacific Northwest Forest Collaboratives Workshop that's held annually. We have 5 sponsors. We have Hampton Lumber, or ODF, for the Forest Service, Beneficial State Bank, and Timberline. So thank you to our sponsors. Thank you to our presenters and our session leads. Please ask any questions you'd like about the webinar. Reach out to me. There will be more. So have a great day. Thank you everyone for joining us.